Hi, this is Mike DeBliss. This is a webinar on government information gathering. It's going to be divided into four parts. The first part is IRS summons power, grand jury subpoenas, and search warrants. The second part is defenses and privileges. The third part is Covell agreements. And the fourth part is international evidence gathering. Once again, my name is Mike DeBliss. I'm a partner in the law firm of DeBliss Law. And my presentation to you today is based on my studying of this topic and of this area in school, as well as practical and hands-on experience that I've gotten over the last 2 years helping clients that have experienced some of these same issues. So I speak to you through experience, but of course, as an attorney, I'm always learning, and with that in mind, I always try to be open-minded. So this is by no means the only way to tackle IRS summonses. This is merely my perspective on things, and I am always available to talk to anybody about this if any questions come up. So without further ado, we'll jump into the webinar. We're going to begin with the summons power. Basically, under 7602A, the IRS has the power to do three main things. The first is examine books and records. The second is to take testimony under oath. And the third is to issue summonses to taxpayers or any other person the IRS may deem proper. Now, in most criminal investigations, agents usually resort to a summons only when informal requests have proven inadequate. So the idea is to try to obtain what's needed in as friendly terms as possible. So it's often easier to just pick up the phone and ask for documents or stop by a witness's home or place of business rather than issue a summons. Now let's talk about the rules for issuing summonses. Summonses can be issued by three sets of people. The first is the IRS examination personnel, the second is IRS collection personnel, and the third is IRS CI personnel. Now let's talk a second about the difference between a subpoena and a summons. I oftentimes find that it's easy to confuse the two, and some people interchange the terms as if they're the same thing, but they're not. With a summons basically can only be issued with judicial approval. A subpoena, on the other hand, does not require judicial approval. So that's very important to keep in mind. It's oftentimes harder to obtain a summons than, of course, it is to issue a subpoena. Now, how does the IRS serve the summons on the taxpayer or other target? There's three main ways. The first is hand delivery to the witness. The second is leaving a copy at the last and usual place of abode. And the third is that, assuming it's a so-called third-party record keeper summons, delivering it by certified or registered mail. Now, what might a summons ask for in the first place? Well, there's two main categories of things it might ask for. The first is testimony, and the second are documents. By testimony, what we're referring to here is something like this. Come in at this time and at this place and tell us about X, Y, and Z. Sometimes that tell us is formalized. There are formal questions and answers that are given, and it's recorded, much like a deposition. As far as documents go, well, they refer to books and records. When CI, Criminal Investigation, issues a summons, it rarely does so for testimony because taxpayers typically plead the fifth at the advice of their attorney. So it's much more common that books and records are sought through a summons than testimony. So what kind of notice are taxpayers entitled to when the IRS issues a summons to a third party? That question depends on two main things. First, who issues the summons? And second, who's the person receiving the summons? And as you can see here, when I mentioned point A, I listed CI or examinations as two possible groups that might issue it. And then with respect to B, I mentioned a third-party record keeper. And that's going to come up later on in the webinar, and I'm going to explain that in a little bit more detail. Now, if the taxpayer is entitled to notice, then he has the right to intervene in the summons enforcement case or bring an action to quash the summons. Now, many criminal cases begin as civil tax controversies. Generally speaking, the IRS must notify taxpayers being examined of the issuance of summonses to third parties, and that is under Internal Revenue Code 7609. But there are circumstances when a taxpayer is not entitled to notice of a summons on a third party, and those two circumstances are listed at the bottom of the slide. The first deals with circumstances where the summons is issued by a criminal investigator of the IRS in connection with an investigation. And that investigation has to relate to the enforcement of the Internal Revenue laws. So that would be the first condition where the taxpayer is not entitled to notice of a summons on a third party. The second circumstance would be where a court determines that there is reasonable cause to believe that the giving of notice may lead to attempts to conceal, destroy, or alter records relevant to the examination. And what I oftentimes like to compare this to is a situation where the police have a search warrant for an apartment, and they suspect that there are drugs in the apartment, and they request specifically a no-knock search warrant. A no-knock search warrant means that they do not have to knock and wait the usual 10, 15, 20 seconds before they can ram the door down for fear that the drugs could be flushed down a toilet in the time that it takes them to enter the apartment. So a no-knock warrant would necessarily allow them to knock the door down and get inside right away for fear that the evidence could be thrown away or the evidence could be destroyed very quickly. And basically the same theory applies here with respect to the second circumstance, again, where the court determines that there's reasonable cause to believe that the giving of notice may lead the taxpayer to try to hide, destroy, or alter records. And you can probably envision certain scenarios where that might happen by the third party, by notice to the third party, and then the third party informing the taxpayer that they have received a summons, and that could potentially lead to the destruction of evidence that is needed by the third party to, or that's being requested by the government from the third party as a part of the summons. Let's talk about summons enforcement proceedings. As I discussed a little earlier, a summons is not self-enforcing. And by not self-enforcing, that's just a fancy way of saying that the government has to go to court to get judicial approval before the summons is official and before the summons has any force. And as it says here, it must be enforced by an action in federal court. If the taxpayer refuses to comply with a summons, the government has to go to court in order to enforce it. A summons enforcement action begins with the government filing a petition seeking an order to show cause, accompanied by an affidavit of the issuing IRS agent. The affidavit provides the prima facie case to demonstrate compliance with the requirements for enforcement. Now I'd like to back up a little bit to talk about the second point where if the taxpayer refuses to comply with a summons, the government has to go into court to enforce it. Let me give you an example here. Let's suppose that the revenue agent issues a summons to Tom. Tom's our taxpayer. Now, Tom doesn't respond by the requested response date. The revenue agent would then refer the matter to the Office of IRS Chief Counsel. They are the attorneys in the IRS. If the agent wants to enforce a summons, an attorney from IRS Chief Counsel's office must write a letter to the Department of Justice. In that letter, the IRS Chief Counsel attorney must state the basics, that the revenue agent issued the summons, the taxpayer did not comply with it, and as a result, we are requesting you to obtain an order from the court to enforce the summons. Now, just to make sure that everybody is awake, I've got a quick question here. Is a summons self-enforcing? As we've already discussed, the answer to that question is no. The next question that comes up here is, what must the affidavit consist of? Well, it must consist of a showing of 4 main things. And these are sometimes referred to as the Powell factors. How do we get the name Powell? Well, it comes out of a federal court case. It wasn't a name that was just pulled out of the sky arbitrarily. It does come out of a federal court case in which Powell was a defendant. The main factors that the government has to show in order to, or what the affidavit must consist of, is 1, that the summons was issued for a legitimate purpose, 2, that the material sought was relevant to that purpose, 3, that the information sought is not already within the possession of the IRS, and 4th, that the administrative steps required by the Internal Revenue Code have been followed. Now, I would like to expound a little bit on the second and the third requirements. The second being that the material sought is relevant to the purpose. What you should know is that relevance is defined very broadly. It's not a narrow interpretation. It means anything that is potentially relevant. So as you can already begin to make out here, these factors are definitely viewed in a light that is most favorable to the government. The third requirement I'd like to expound on a little bit more has to do with the information sought not readily being within the possession, not already being in the possession of the IRS. What's interesting about this third requirement is this: the fact that the IRS already has the information doesn't matter if it's not readily retrievable. So let's talk about that for a second, and let's talk about it in this context. Let's say that the IRS says to the taxpayer, give us a copy of your tax return for tax year 2008. And let's say, for all intents and purposes, that the IRS already has it in its service center. But let's add another fact here, and let's say that although the IRS has the taxpayer's 2008 return in its service center, it's having trouble locating it. Now, as we tax professionals know all too well, finding something in the IRS Service Center can sometimes be a dangerous task. Many human beings have wandered into those archives of the service centers, never to be seen again. So the point being here is that even though the IRS may physically have possession of the return, so long as they can't find it, that will satisfy the third requirement, that the information sought is not already within the possession of the IRS. So the third requirement is liberally construed and in favor of the IRS. Now, once the government makes out its prima facie case, the burden of going forward shifts to the taxpayer. The taxpayer has the right to challenge the summons on any appropriate ground. And as you can see here, I mentioned the grounds that the taxpayer can raise. The first consists of the 4 factors set out in Powell, that they have not been satisfied. So what the taxpayer might find is that 1 or 2 or all of the factors haven't been satisfied. And so the taxpayer's defense would essentially be trying to negate 1 or more of the factors set out in Powell. The second is that the summons or subpoena is unreasonable as to place or time. The third is lack of proper service. And the fourth is that the summons was issued in bad faith. Now, what you see next to bad faith is a Supreme Court case that I've cited. It's the case of United States versus Clark. And I'd like to expound a little bit on that case. It's a relatively new case. It came out on June 19th, 2014. And basically what the court did, the Supreme Court of the United States did, is that it reaffirmed the right of a recipient of an IRS summons to challenge the summons by examining an IRS official in an adversarial proceeding, meaning in court. The U.S. Supreme Court ruled unanimously that taxpayers have a right to challenge an Internal Revenue Service summons enforcement action in court when they can show, and here's the operable phrase, that the tax agency might have issued the summons in bad faith. Might have issued the summons in bad faith. What's interesting about that is that they don't have to prove definitively that the tax agency might have issued the summons in bad faith in order to have a right to challenge it. Here's some language that helped explain exactly what the court meant by that. Justice Keegan said that, quote, a taxpayer has a right to conduct an examination of IRS officials regarding their reasons for issuing a summons when he can point to specific facts or circumstances plausibly raising an inference of bad faith. Once again, when the taxpayer can point to specific facts or circumstances plausibly raising an inference of bad faith. That's the catchphrase. So what that catchphrase has to be compared to are conclusory allegations. Conclusory allegations are not going to be sufficient in order for the taxpayer to have the right to examine an IRS official in an adversarial proceeding. Ironically enough, the 9 justices, while they found in favor of the petitioner in the case, they sent the case back to the 11th Circuit Court of Appeals and said that the court had wrongly decided that IRS agents could be examined at an evidentiary hearing. And the reason why they did that is because the 11th Circuit Court of Appeals ruled in favor of the petitioner, but their reasoning was faulty. And they said that the taxpayer could do so merely by alleging conclusory allegations. And as we've learned now from the language of the Supreme Court case, conclusory allegations are not sufficient. The taxpayer has to point to specific facts or circumstances that raise an inference of bad faith. And what's interesting about this case is that it is particularly relevant today, especially since IRS examining officers have been issuing summonses to taxpayers for failure to respond to information document requests during the information gathering phase of an examination. And as a result, that is ripe for many challenges by the taxpayer. And what's interesting here is that in an enforcement proceeding, and the court's role is not to second guess the judgment of the IRS, but to determine whether the particular summons is a legitimate exercise of the IRS's investigative authority. So for all intents and purposes, that's the standard that the courts are governed by. And as you can tell, it's a very watered down standard. It's not high. It's not a high watermark by any stretch of the imagination. Let's talk a little bit now about third-party record-keeper summonses. Now, normally taxpayers are not entitled to notice if a summons is served on a third party during a criminal investigation. The exception to that rule is a third-party record-keeper exception. Now, who is a third-party record-keeper? Well, the Internal Revenue Code gives us a list of third-party record-keepers, and we have here a partial list. These are the main ones. They are banks, consumer reports or agencies, credit card companies, brokers, attorneys, and accountants. So going back and looking at the general rule that taxpayers are not entitled to notice if a summons is served on a third party during a criminal investigation, that is our basic rule. But the exception is if the third party happens to be one of these 6 record keepers. If it does, then the taxpayer is entitled to notice of that summons, notwithstanding the fact that the case might have turned criminal. Here's a question just to make sure that everybody's still following. Which of the following is not a third-party record keeper? Bank, broker, attorney, taxpayer's employer. I think that the answer is obvious. The answer is D, of course. If a summons is issued to a third-party record keeper, the taxpayer has 2 options. He can bring a proceeding to quash the summons or intervene in a proceeding brought by the IRS to enforce the summons. Now let's move on to the John Doe summons. This is a fascinating area of the IRS summons power, and it is very appropriate for today in light of the foreign asset reporting and the IRS's emphasis on rooting out offshore tax evasion by targeting taxpayers with undisclosed foreign bank accounts. And you'll see the context in which this arises. Let's start out with a simple definition for the John Doe summons. It is a summons issued to a third party, like a bank, seeking information regarding taxpayers whose identities are unknown to the IRS. Let me go back and emphasize. It seeks information regarding taxpayers whose identities are unknown to the IRS, thus the name John Doe. So the purpose of a John Doe summons is to find out who the taxpayers are so that an investigation may be undertaken. At this stage, the IRS has no clue whatsoever who the taxpayers are, meaning their names, and that's why this is dubbed the John Doe summons. As you can see here, there in the last bullet point on this slide, there are times when the IRS knows or strongly suspects that some tax hanky-panky is going on, but it doesn't know who's committing it. And here is an example that I'm sure we can all relate to. The IRS knows that lots of Americans have foreign bank accounts that they have not reported on their tax returns. I think that the latest figure reveals that there is over $1 billion that is parked offshore in foreign financial institutions that has not been reported. And when you think about that number, it is astronomical. And obviously, there is a lot of interest income that is generated on the high watermark value of those accounts. The IRS is foaming at the mouth and sees that as a large source of revenue that has eluded the U.S. government's coffers. And so they are aggressively pursuing taxpayers with unreported foreign bank accounts to get them to come forward, disclose the accounts, and pay penalties, recognizing the fact that the interest income generated by these accounts is ever so light. The IRS knows all too well that the FBAR penalty is the way they are going, is where the money is at, meaning the penalty for failure to report the account by the respective deadline. And many taxpayers are caught between a rock and a hard place here. And as a result, there's a number of IRS voluntary disclosure programs. We won't get into that in this webinar, but it just gives some background to you as you study this topic. So getting back to this example, as we know, taxpayers have parked a lot of money offshore, and they haven't reported these bank accounts, nor have they reported the interest income that was generated by these bank accounts. The IRS knew or suspected that these accounts were with banks like UBS or Credit Suisse, but they didn't know the names of the account holders. So what did they do? And again, this is going back a couple of years. This is going back before FATCA. Under these circumstances, the IRS used the device of a John Doe summons. Essentially what they did was they issued UBS and Credit Suisse a John Doe summons. And the summons substance of that summons was this: quote, "Give us information on Americans that have accounts with your bank," end quote. Now, let's go back to something we've talked about here already. The government must obtain judicial approval from a magistrate judge for a John Doe summons. And I'm sorry, actually this is a new concept. The government, again, must obtain judicial approval from a magistrate judge for a John Doe summons. The prior judicial approval is not a safeguard for the taxpayer. And why do you suppose it's not a safeguard for the taxpayer? Well, for the simple reason that the IRS doesn't know who these taxpayers are, and they can't be hauled into court or brought into court to defend against this summons. So it's basically like having an empty chair. And here we have a question. Why are the proceedings ex parte? There are two choices here. The IRS doesn't know who the taxpayers are, so it can't invite them into court. Or B, the IRS doesn't want to have to deal with an adversary. Well, the simple answer is A. The IRS doesn't know who the taxpayers are, so it can't invite them into court. Just discussed in terms of the John Doe summons. The issue here is this. Can the IRS gather information on a known person as well as an unknown person through the same summons? In other words, does it have to obtain a judicial approval from a magistrate judge for the unknown person, as would be the case for a John Doe, or since a known person is already a party to the summons, can it somehow bootstrap the unknown person into that same summons so that there's no independent requirement for proving the John Doe elements for the unknown person? I realize that that's a mouthful, but I think it'll be understood when I give you this next example. This is the general rule. A summons may be issued for a dual purpose. It may be used in order to obtain information relating to an identified taxpayer as well as an unidentified taxpayer. And there you see a case name, Tiffany Fine Arts case. This is an awesome example for helping to explain this distinction and how the government attempts to bootstrap the unknown person into the summons that it has for the known person so that it can avoid having to go before a magistrate judge and independently prove the requirements for a John Doe summons. Here are the facts. In Tiffany Arts, a tax shelter promoter sold shelters to unknown third parties who were investors. The government was able to identify the tax shelter promoter by name and was already auditing him. The government wanted to audit the investors in the promoter's shelters, but it didn't know their names. One can imagine why they probably wanted to investigate the investors. In cases like this, it is oftentimes helpful to have cooperating witnesses come into court to testify against the promoter. It strengthens the government's case, or so they think. And so the investors would probably, once they are targeted and threatened with the possibility of prosecution, they oftentimes start talking and provide information to the government that is helpful in the prosecution of the promoter, who the government wants more than anything else. And so that's one of the reasons why the government wanted the names of the investors. And so the government needed to know exactly who these unknown parties were so that it could investigate them and possibly shake them down and get them to testify against the promoter. but it didn't want to follow the cumbersome John Doe summons procedures. In other words, it didn't want to have to go into court, stand before a magistrate judge, and have to prove those requirements that are necessary for a John Doe summons. And this is what the government argued. The government argued mixed circumstances. They argued that they had an actual interest in the investigation of both the promoter and the investors, who were otherwise known as John Does. And therefore, they said they didn't need ex parte approval, meaning they didn't have to prove the elements that were necessary to obtain a John Doe summons against the investors. The court held that as long as all the information sought was relevant to a legitimate investigation of an identified taxpayer, here the promoter, the government didn't have to follow the John Doe summons procedure to learn the identity of the unidentified investors. Let me repeat that again. The court held that as long as all the information sought was relevant to a legitimate investigation of an identified taxpayer, here the tax shelter promoter, the government didn't have to follow the John Doe summons procedures to learn the identity of the unidentified investors. What does that mean for the government? Well, essentially that they won the lottery. And this is kind of what the government, what the court has given the government carte blanche to do. By investigating the promoter's own tax liability as a basis of inquiry into whether it reported income from these unknown investors, the IRS was able to avoid these cumbersome ex parte procedures required for a John Doe summons. And thus, it could use the General Administrative Summons rules, which require no more than satisfying the minimal requirements of Powell. So what happened here is that the government got a windfall. They didn't have to appear before a magistrate judge and convince the magistrate judge that the requirements for a John Doe summons have been met. Instead, they were able to use the General Administrative Summons rules, which were not as difficult to satisfy as the John Doe summons requirements. Again, the General Administrative Summons rules only require satisfying the minimal requirements of Powell. Now, there is a case that came up where the government went too far. That's the case of U.S. versus Gertner. I'm not going to get into the details or the facts of that case, but the government's argument there was mixed circumstances. And mixed circumstances is, again, just a fancy way of saying that the government was able to identify one taxpayer that they were investigating, but that there was a group of other taxpayers whose names they did not know. And so mixed circumstances refers to that. The court held that the summons was not enforceable and that the IRS's use of the regular summons was not in good faith. So the court basically could see through the veneer and could see through the government's plan to try and bootstrap the unidentified taxpayers in with the identified taxpayers so that they only had to satisfy the Powell requirements. We're going to transition now into grand jury subpoenas. Grand jury subpoenas are a major alternative to the traditional administrative route involving use of a summons. The grand jury subpoena is more powerful than the IRS summons. So how does the grand jury subpoena compare with the IRS administrative summons? There are three main ways. First, a grand jury subpoena is self-enforcing. In other words, the government doesn't have to go to court to enforce it if the taxpayer violates the subpoena. Failure to comply with a grand jury subpoena constitutes contempt in and of itself. So the mere fact that the taxpayer disregards the subpoena, that automatically triggers contempt. The IRS doesn't then have to go to court and get the judge to enforce it. Second, the witness must appear before the grand jury alone and cannot have his attorney present. A witness appearing, on the other hand, a witness appearing pursuant to an IRS summons does have the right to have an attorney present. Finally, an IRS administrative summons to a third party requires notice to the taxpayer. When a third party summons requiring notice is involved, the taxpayer will oftentimes know about the existence of the investigation and the direction that it has turned into. The grand jury subpoena, on the other hand, has no notice requirements. So the taxpayer will be in the dark if a third party receives a summons in reference to information pertaining to the taxpayer and won't know the direction of the investigation. Now we're going to move on to search warrants. The IRS has increasingly used a search warrant as an investigative tool. Search warrants involve the Fourth Amendment. There are three requirements for search warrants that have to be met. The first is probable cause to believe that a crime has been committed. The second is probable cause to believe that the taxpayer committed that crime. And the third is probable cause to believe that the premises to be searched may provide information pertaining to the crime. Here's a question just to make sure that everybody's still awake. What is not one of the requirements for obtaining a search warrant? A, probable cause to believe that a crime has been committed. B, reasonable suspicion that books or records will be found in the location to be searched. If you selected B, you would be correct. Reasonable suspicion is not one of the requirements for obtaining a search warrant. Even if an IRS special agent believes that he can establish probable cause to seek a search warrant, what's interesting here is that he must still consult with an attorney from IRS's Chief Counsel Office. So this is kind of like this is a bit of a safeguard, and it's basically saying that they don't want IRS special agents arbitrarily seeking seeking search warrants or approving search warrants rather. So while the IRS special agent can seek a search warrant, he must still consult with the attorney from IRS's Chief Counsel's Office, and that attorney from Chief Counsel's Office must review it and approve the search warrant. After obtaining approval, the special agent may ask an assistant United States attorney from the Department of Justice to apply for the search warrant. So it goes back to the IRS special agent. It's kind of like a circle. It is initiated by the IRS special agent in the form of the special agent seeking the warrant. It has to work its way up to the attorney from IRS's Chief Counsel's Office. That attorney reviews and approves it. And then after obtaining approval, The special agent then has the green light to ask an assistant United States attorney from the Department of Justice Tax Division to apply for it. What about cases where the target is a doctor, a lawyer, an accountant, or a public official? In those cases, search warrants require the approval of the Assistant United States Attorney in charge of the tax division. And an interesting case about or relating to search warrants is the case of United States versus Leifkowitz. Our last topic here is sting operations. Sting operations are what exactly is a very thing that first comes to mind when you think of them. It's cases where the government is going after organized crime. And of course, it goes back to the days of Al Capone and a lot of the organized crime bosses in the Chicago area and New York. Sting operations were very popular then. They're not used as frequently today as they used to, but nevertheless, it is still an investigation device used by the government. We're going to stop here. This is the end of the first webinar. The second webinar will pick up with defenses and privileges. So it was a pleasure presenting this to you today. If you have any questions at all, feel free to send me an email at mjdebliss@deblisslaw.com.